All right, everyone, thanks for coming out, and especially on such short notice, because it was a last-minute addition to the schedule, and that you'd all rush in to make us feel good leaves us quite grateful. I'm Jess Braven. I've covered the Supreme Court for the Wall Street Journal for 20 years. Although I probably will be best remembered for having written the biography of Squeaky Fromm. Go figure. Our panel is called Trump versus the Judiciary, and I think it's a topic that we all know a bit about, but as the entry explains, I mean, you should know there have been, since President Trump began a second term, there have been more than 300 lawsuits filed against his policies. There have been dozens of injunctions issued by judges after finding that those policies were probably unlawful, and the president has been disappointed, you might say, in some of those rulings, and he's made his feelings quite clear. In fact, even before President Trump took office a second time, there were suggestions in the air that maybe some decisions might not be followed, and we've seen a kind of rhetoric that's really quite new in complaints from the executive branch about what the judiciary is doing. So let me quickly ask you a question just to get our panelists oriented. You know, the entry says, are we headed towards a constitutional crisis? A show of hands, please. Are we headed towards a constitutional crisis? Okay. Well, our work is done.
Let's go hiking.
Let's go hiking. Okay. So now we have a sense of where they're coming from. I'm sure you will reassure the audience about how stable our system is. Let me tell you who our panelists are. In some way, we're quite fortunate to have really two of the most accomplished legal minds and also legal actors, because they're involved in cases as well before the Supreme Court and other courts. Neil Katyal heads the appellate practice at the law firm Milbank. He's a professor at Georgetown Law School, and he has had several important positions in the executive branch, including acting Solicitor General. Pam Carlin here is a professor at Stanford Law School and co-director of their Supreme Court litigation clinic. She too was a senior official in the Justice Department's Civil Rights Division, and she was a commissioner on the California Fair Political Practices Commission, which regulates campaign spending or funding and so forth in California. And they've both done many more things, but I'll leave you to find that out on Google. Let's get moving to our questions. So I was going to start here with the news, and if I might start with you, Pam. On Friday, the Supreme Court gave us an opinion in a case called Trump versus Casa, and that opinion, although in some ways related to birthright citizenship, really was about the ability of district judges to issue universal injunctions, and the Supreme Court majority was very skeptical of that and seemed to really roll those back. So is the problem solved?
No.
Oh, okay.
No, so here's the problem. If you have a policy that's clearly unconstitutional and you have to bring a lot of lawsuits so that everybody can benefit from a holding, it can take years to get there. And I thought one of the things that was most telling and weird about the argument in the Casa case as opposed to the decision was the Supreme Court said, look, we can get this all decided very quickly. So it shouldn't be one district judge somewhere in the country or somewhere else in the country deciding this issue for a long period of time. If the Supreme Court had any guts, what they would have done, I think, is they would have issued their opinion and said, and we're now granting certiorari right here, right now, on whether or not the birthright citizenship executive order is constitutional, and we'll get it all resolved. Instead, they're sending it back. They didn't tell the lower courts what they're supposed to do with the lawsuits that were brought, the lawsuit that was brought by the 23 states. They have 2 pages in the opinion that essentially says, it might be that you could get a universal injunction in those states, but we don't know. We're just going to send that back, which means there's going to be another round of this litigation and the like. And this doesn't do anybody any good at all.
Well, that's optimistic, but there were, and of course...
And I should say the other thing that I was shocked by, actually, during the oral argument is the Solicitor General was asked, suppose the Second Circuit, which is the intermediate appellate court between the trial courts and the Supreme Court, suppose the Second Circuit held that the birthright citizenship executive order is unconstitutional. Will the government obey that? And his answer was, generally we obey the decisions of the Second Circuit in the Second Circuit, which is kind of shocking. I mean, you wouldn't have given that answer, would you?
Nobody I know who's ever served in government would give that answer.
Well, so you don't know John Sauer.
I don't.
Lucky us.
Exactly. I mean, I agree with you, Pam. First of all, thank you for having me, and it's a privilege to be with these two. Pam gave, I think, one of the best arguments in our lifetimes in a case called Bostock 5 years ago. If you ever want to hear just a masterful oral argument, go on oyas.org and listen to it. It's mind-blowing. And Jess has been covering me for 20 years now, since my very first case, Guantanamo. So I agree, Pam, to a point. I think that the decision, by the way, this is my nonprofit's case, so take what I say with a grain of salt. We lost yesterday 6-3. But I don't think it's as extreme a loss as some of the media is painting it out to be, or that the president, in declaring absolute and total victory, is painting it out to be. The court didn't rule on the merits one way or the other. It just simply said that the nationwide injunction that the private plaintiffs, that is my clients, were seeking was impermissible. But they said with respect to those folks, they could file a class action. So within 2 hours of the decision, we were in court and we filed a class action. And it may be that we can get the same general form of relief there. It might take longer depending on which court is hearing it. There are restrictions on class actions, but and I don't think it makes much sense in the end, because the Constitution contemplates a uniform rule of immigration. The idea that you might be a citizen in one place and not another is kind of crazy. But there's that, and then there's also, as Pam notes, the separate exception for states that are bringing litigation. And there the court says maybe you could have a larger injunction with respect to those states. And with most of Trump's actions, I think you have a number of state attorneys general who are willing to bring lawsuits and seek those nationwide injunctions. So it's not clear to me that it's going to have the devastating practical consequences that some are predicting. As far as Pam's point about, well, if the court had guts, they would have granted certiorari, reached the merits, and ruled against birthright citizenship, I'd say two things. Number one, I think Pam's absolutely right that this is an easy case once the Supreme Court gets it. I mean, the idea that the 14th Amendment doesn't protect this is to use a technical legal term, poppycock. It's ridiculous. But second, and it's connected up to Pam's point about the administration and executive branch defiance of the courts. The courts are always, since Marbury versus Madison, worried about a clash between the executive and the court. The courts don't have armies to enforce their judgments. They just have legitimacy. And so if you go back over the 200-year history and you ask yourself, when do challenges to executive power succeed? I mean, first of all, if you're the president and you cite executive power, it's really hard to lose. Like, I represented the government, I'll tell you, it was hard to lose. It's kind of like failing a class at Yale. You really got to try. So, Trump's managed to do it, I think, 19 times already in 6 months, but he's trying. So when courts, though, particularly the Supreme Court gets at this, I think they only want to rule against the president when they absolutely have to. And so there's procedural tactic after procedural tactic to delay litigation. And so to me, it's not surprising. I don't think it means that they don't have guts. I think it means that they're trying to husband their legitimacy and save the constitutional confrontation for when you really need it.
And by the way, Neil, in the reference to that anniversary you mentioned, I brought my Guantanamo hat
Excellent.
today. So you can see the genuine Guantanamo Bay Bar Association ball
And
cap.
Gitmo's back.
That's right. Well, everything that's old is new again. Let me read you a passage from the Chief Justice's year-end report that was published on December 31st. He wrote, disappointed litigants rage at judicial decisions on the internet, urging readers to send a message to the judge. They falsely claim the judge had it in for them because of the judge's race, gender, or ethnicity, or the political party of the president who appointed the judge. Public officials have engaged in recent attempts to intimidate judges, suggesting political bias in the judge's adverse rulings. Public officials have a right to criticize their work, but they should be mindful of that intemperance in their statements can affect people out there. And then finally, another threat to judicial independence is defiance of judgments lawfully entered. Every administration suffers defeats in the court system, sometimes in cases with major ramifications. Within the past few years, elected officials from across the political spectrum have raised the specter of open disregard for federal court rulings. What was he getting at, Neil?
So, I mean, well, first, the president has said a bunch of things. Like, for example, after Judge James Boasberg blocked the deportation flights, Trump called him a, quote, radical left lunatic, troublemaker, and agitator. Chief Judge Boasberg is appointed by, I think, President Bush. I mean, he's a Republican appointee. He's, those of us in Washington who know him, he's like the most centrist. The idea that he's I mean, if he's a radical lefty Marxist, I don't know like where anyone else in this country stands. He's like the opposite of that. So you've got an attack on the judiciary by the president. The vice president floated the idea that, you know, you don't have to follow court orders if they interfere with executive power. You've had the deputy chief of staff, Stephen Miller, calling judges Marxist and saying that you don't have to follow judicial decisions. So I think the chief is reacting within that ecosystem, and he's trying to stand up for the judiciary. He said, for example, for more than 2 centuries, it's been established impeachment is not an appropriate response to disagreement concerning a judicial decision. The normal appellate review process exists for that purpose, because you had all these people calling for the impeachment of Chief Judge Boasberg and other judges. So this is, I think, a really pernicious, dangerous trend. When I was in the government, the idea, you know, we would sometimes criticize a judicial decision, but we would certainly never do it in personal terms. We would just criticize the logic behind a decision. That's absolutely fair play. What's going on here is unprecedented and very scary, and it leads to death threats against these judges. And we've already had, you know, in the past, you know, judges have been killed. And, you know, unfortunately, in our system, we have 0 protection right now for retired justices, like Justice Breyer. They have no protection right now. And so there are real gaps in the security that judges have, and unfortunately, this rhetoric is posing some real dangers.
You know, you mentioned, Neil, that courts have historically tried to avoid getting into confrontations, starting with Marbury and President Jefferson, going on through the years. Do you think, and I'd like both of you to talk about this, do you think that this rhetoric is effective in the sense that it does, maybe even on a subconscious level, make judges think twice before ruling against the government? I mean, for example, look at the Supreme Court itself. At the beginning of Trump's term, they issued some decisions on some emergency applications against the administration. But for the past couple of months, the administration has won all of them. And so I'm wondering, you know, do you think does it work, or are judges impervious to this type of language?
I mean, I think you should separate the Supreme Court from the lower federal courts. The district judges are doing their job, and they're not sort of saying, we want to hold back and we want to avoid saying anything that might upset the president. The Supreme Court is acting very differently from them, and I think it's worth noticing that. And the Chief Justice, you know, has finally noticed what I think everybody else who's observed Donald Trump for the last 10 years already knew, which is he is an incendiary politician. And the Supreme Court, you know, if you back up 1 year and you think about Trump against the United States, the Supreme Court basically told him nothing he does can result in any consequences to him. And he just feels completely freed by this. And this time around, he hasn't brought into the administration the kind of traditional folks who go into an administration, so that you have, you know, I don't know how many of you have seen the stories in the Times and the Post about the whistleblowing by Mr. Ravani, who was 10 years of litigating for the government immigration cases. So this is a guy who's prepared to kick people out of the country like that. I mean, you know, the people who litigate those cases are really hard ass. And he was fired from his job, even though he's a career civil servant, after he said in court that the government had made a mistake in sending Abreu Garcia out of the country. And he was fired for that. And he then issued, after he was fired, he's now filed a whistleblower complaint where he says that the number 3 person in the office of the Deputy Attorney General, which handles immigration and criminal cases and the like, said, we have to have a discussion about whether to say fuck you to the courts. And that's coming from the top down, that's the view of the administration. And it was really, again, shocking to me that at the confirmation hearings for the person who allegedly said this, one of the senators said to him, I think it was Senator Schiff, said to him, did you say at this meeting that we have to say fuck you to the courts? And I think there are really only 2 answers to that question, right? Yes, I did, and no, I didn't. And he said, I don't recall saying that, right? Which is, I guess, his desire to avoid a perjury prosecution somewhere down the road, but is unbelievably telling about where this administration thinks itself vis-a-vis the courts, which is it has no respect for courts. It obviously has no respect for Congress.
And I mean, in the position you're talking about, this guy at the convention, this guy is nominated to be on the Court of Appeals. Like this is not some minor position. I agree, Pam, with everything you said. And I do think Trump versus United States, the 6-3 decision that many of us talked about last year in a room just like this, I think is a big root cause of a lot of this, because the Supreme Court said basically if the president is acting arguably within the scope of his duties, then he's immune from criminal prosecution. And that meant like what he did on January 6th somehow was within the scope of his duties. And the court said, look, we're worried about the slippery slope that otherwise would happen if you could prosecute a president. I think you should be worried about the slippery slope that happens if you can't prosecute a president, as we're seeing right now. Jess, it's hard to know from the outside whether the pressure is affecting the Supreme Court or not. Certainly, if we look at the data on the Supreme Court, it would show that it is. So in Trump 1, there were 41 emergency applications to the Supreme Court by Trump. By the way, that's like crazy numbers compared to any other administration. When I ran the Solicitor General's office for, I think, 15 months, I didn't file a single emergency application. I think we filed 3 or 4 in the total of the 8 years of the Obama administration. So they filed 41, they won 28 of them. This time they have filed 12 emergency applications. They've won 11 of them. So, there is, if you were looking at that data, if you're looking at the birthright citizenship case, you're looking at a Supreme Court that right now is very much siding with the president on these big issues. Now, when you're on the emergency docket, it doesn't mean they're deciding it for all time. They're just saying, we're not going to let this injunction, this command that what president is doing is illegal, we're not going to let it take immediate effect. So just to give you a concrete example, another one of my cases is the case involving Kathy Harris, who runs the Merit Systems Protection Board, an independent federal agency. And there are a bunch of independent agencies that have been set up in the wake of the New Deal in which there's supposed to be some insulation between the head of the agency and the administration, that the administration can't just task that person and say, do X. That most prominent example is the head of the Federal Reserve Board, Jerome Powell. So Trump comes in and says, I think all of these congressional laws that insulate these independent agencies are unconstitutional. And so he goes ahead and fires Kathy Harris, as well as the heads of some other independent agencies, even though the congressional statute doesn't allow him to do it. And then he goes to court and says, well, that statute's unconstitutional. I get to do what I want. I'm the president. So we filed this case. We won it in the trial court, won it in the nation's second highest court. Trump filed an emergency appeal to the Supreme Court to say, fire Harris, let my person come in. And the Supreme Court agreed and said, temporarily at least, we're going to let that happen while the case plays out in the lower courts. We're too worried about interfering with presidential prerogatives. And that pattern is replicated in those other 10 of the 11 cases, 10 of the 12 cases that I mentioned.
Well, one of the things that I thought was really striking in the short opinion that the court gave in your case was that they said, well, we can see how all these people, but not the Federal Reserve, right? I mean, which I thought showed exactly what's going on there in some sense, which is they don't want to totally destabilize the country, and they don't think that it destabilizes the country to fire the person who's responsible for overseeing merit systems protection, the person who's supposed to oversee whistleblowers, the person who's supposed to oversee protection of federal unionized employees. All of those people it's fine to fire, but not the Federal Reserve.
Yeah, and it's the agenda here by the administration is to radically remake what the federal government is and make it responsive just to the presidency. And if you think back over American history, we had like the Pendleton Act of 1883 designed to create this merit-based civil service with career experts. And Pam and I got to see this all the time at the Justice Department. There's nooks and crannies of the federal government with these non-political people who are just experts in snails or in human genetics or whatever. And those people are now being hollowed out, and the administration is saying, we've got the right to fire any of them because they are government employees and we get to control the government. And that has certainly not been the way the federal government has operated for at least 100 years, perhaps longer.
You mentioned, Pam, the case of Kilmar Abrego Garcia, who was mistakenly deported to El Salvador. The government obviously took an extremely aggressive position there and did everything possible to avoid complying with Judge Zinnes's order, even though the Supreme Court had affirmed that one. But they did bring him back finally, right? They did. And so, is it really just, is there an argument that there is a lot of hot rhetoric and maybe they want to change the atmosphere, but when it comes to the, the bottom line, they will obey?
I don't know whether they're going to obey or not. I mean, this is from the administration's point of view relatively low stakes because they're now going to try and deport him on some other grounds. And the real question is, where does he get deported to? Not, is he deportable? It was simply that there was an order from an immigration judge that said you can't deport him to El Salvador because he has a risk of being killed if he goes there. So, that's not as big a deal as something that orders the president to put somebody back into office that he's kicked out, or that orders him to start giving contracts back to people. I mean, the number of contracts that have been abrogated without the required process behind them. If you work for a university right now, universities are absolutely terrified. What happened yesterday to Jim Ryan, who's the president of the University of Virginia, is absolutely appalling and disgusting. And those cases, I think they'll try to resist, and they'll try to resist, and they'll try to resist.
Let's turn the telescope around and look at the way that the administration frames this. The crisis, in their view, is the courts defying the president's will. And the way they see it, look at all these lawsuits that have been filed against our administration. That didn't happen in other administrations. And look at all these orders against our administration. That didn't happen before. We are being singled out for unfavorable treatment by the courts, and the courts are the ones that are really provoking this crisis.
We're being singled out for being the most outrageous administration in modern American history.
Yeah.
I mean, that's why they're being singled out. They're being singled out in part because the executive orders, and this goes back to something Neil was saying a moment ago, executive orders are supposed to be orders inside the executive branch that tell executive officials how to carry out their job. And there is, as you would expect with the federal government, an executive order about executive orders that's now a regulation. And it says that before an executive order goes into effect, the Office of Legal Counsel, which is essentially a kind of interior Supreme Court within the executive branch, looks at the order and figures out, is it constitutional or isn't it? And when I was there, and I'm sure this is true when you were there, OLC would say, you can't do this at all, or you can't do it this way. Here's a way to do this that would be constitutional. Charlie Savage had a great piece about this, which points out they're not sending these things through the Office of Legal Counsel. They're not sending them to career lawyers to ask, are they constitutional or not? And if you don't have somebody vet your stuff before you throw it out onto the world, chances are you're going to make some mistakes, and that's why they're getting sued so much.
Yeah, I completely agree. I mean, the idea that they're for the first time being sued, I mean, give me a break. I represented the Obama administration. We were in court all the time. There were 45 different lawsuits just against Obamacare alone that we had to fight. So this isn't a new phenomenon. I do agree with Pam. The numbers are higher, 302 lawsuits. That's because you're doing a lot more crazy shit, you know? So like, you know, it's like not that surprising. I think there have been 19 different losses that the administration has had in lower courts, and that's not surprising given the positions that they're taking. And as Pam says, the lack of kind of review over this, and even before you get to the review stage, which they've now bypassed, it's also the inputs. This is not the A-team of constitutional scholars writing this stuff. It's not even the B or C or D team. And so it's not surprising that federal courts are saying, hey, this is unconstitutional.
But, you know, I guess Nick Perillo at Yale, I guess he has studied the phenomenon of non-compliance with judicial orders. It seems that there has always been a degree of, you might say, quiet non-compliance with court orders. You know, they just don't do it. You know, when the government gets ordered to do things, and so, you know, is this really new? Are they just being more transparent about their pushback?
I mean, my time in government, I never, ever saw anyone suggest anything about defiance of a court order at all, from, you know, even the most partisan political appointees to various federal agencies. I just never saw anything like it. And if they did, there was a career core of people, like there were deputy solicitors general, I had 3 of them, who had been there for years and years, like the one who'd argued the fewest number of Supreme Court cases had argued 80. And if there was anything even close to the line, they would come to me and say, hey, you know, the court said this, there's a proposal to do Y. I think those things are in tension, you can't do that. And there was a total culture of compliance. What's happened to all those career officials? They've been fired or they've been driven out. And so they've hollowed out the Justice Department so that they now only get there's no independent review, anyone to say, hey, you're bumping up against this court decision, you might be acting in defiance of it. That's just gone now.
Well, you know, think back to Guantanamo. I remember being in the Guantanamo courtroom, I think in 2004, when Judge Robertson issued an order, stopped the military commission trial at Guantanamo Bay. And from what I learned, there was a discussion inside the administration about whether they needed to obey that order or not. I mean, they, on very high levels in the Bush administration, considered not complying with that order. After the case that you won, Hamdan versus Rumsfeld, which held the Geneva Convention applied to those prisoners, I'm not so sure that the government fully complied with that when, you know, not in the terms of the trials, but in terms of the conditions of confinement with, you know, the CIA detainees. You know, so again, how new is it and how much is it a question of greater candor?
So, I mean, I was in that courtroom and Judge Robertson ruled for us, and within 15 minutes, the military commissions were disbanded, stopped entirely in their tracks. And maybe there was some discussion in Washington about whether they had to do that or not, but that culture of compliance was reflected immediately, and they certainly never tried to push back on it. And I definitely don't think after the Supreme Court decision that they did defy it, including on conditions of confinement. But, you know, look, you're going to have times in administration when someone wants to push the envelope, including maybe if Vice President Cheney back in the Guantanamo cases back in the early 2000s. But the point is, you don't do it in the end. And here, you know, there's much more rhetoric, much more of an indication that they already have done it. For example, Chief Judge Boasberg had ordered that plane to be turned around. It looks like that wasn't complied with. He's now launching an investigation into whether those Justice Department officials should be held in contempt of court. That's just, I mean, mind-boggling for anyone who served in the Justice Department to think that a judge is going to have to order that kind of investigation.
I will say, just to go back to something you were saying earlier, just that there are cases where all the time, structural reform style injunctions don't get fully complied with, which is why you're constantly having to relitigate prison conditions cases and constantly having to relitigate desegregation cases and like where they just haven't fully complied. But I think there's a difference between a lack of full compliance and a deliberate resistance to the order. And I think that's what's different about what we're seeing now, as opposed to, all sorts of cases that have involved whether federal prisons are complying with the Eighth Amendment or the like. Nobody is saying there, we're just not going to comply with the Eighth Amendment. It just turns out they simply don't manage to get everything done that ought to be done.
And maybe to build on Pam's point, just think, in 1974, the Supreme Court held in the Nixon tapes case that the tapes had to be released. And Nixon certainly could have said, I'm not going to comply with that. I'm not going to do it. I could burn the tapes or whatever. He didn't. Ask yourself, if Donald Trump faced that order today, what would he do?
Excuse me. Let me ask a question about the third leg of the stool, which would be the Congress.
What's that?
Yeah, exactly. This
You used the word stool.
What is their role in, say, diffusing this tension or picking the right side or clarifying who really has the power over these issues? What role? What is the very constructive role they are playing right now, and what should their role be?
Well, here's one of the big failures in our Constitution, which is the Constitution was designed to have this idea of separation of powers. And in the Federalist Papers, Madison famously says ambition should be made to counteract ambition, that each branch is going to be jealous of its own power and try and check the others. It turns out, though, that the people who framed our Constitution made one very critical error, which is they thought they were creating a Constitution that would prevent the rise of what we now call political parties. They thought that the way they were setting everything up with federalism and the different branches of government and the like meant there wouldn't be political parties. But there are political parties. And the result of that is that Congress really only checks the president now when one or both of the houses of Congress are from a different political party than the president. Otherwise, they're basically supine. They just don't check their own president. And the campaign finance decisions have complicated this further because they can be primaried if they resist their own party's president in ways that really are a deterrent to people who want to continue to be elected.
Yeah, I completely agree, and I think super PAC funding, which working with Pam's old colleague Larry Lessig to try and challenge in courts, is a big part of where this, of why we're where we are. Congress theoretically should be standing up for American values in these things. The idea that Harvard University would be facing what it's facing, or that that these detention decisions would be decided in such a way. You would think that Congress would do something, but they're not. And one of the problems you've had is that when you have one-party government, as you do now, the House and the Senate controlled by the Republicans, as well as the president, the checking function is utterly gone, whereas when you have divided government, the checking function is almost too strong. That is, you can't get anything done except by executive power. So President Biden was using executive power in all sorts of areas because he couldn't go to Congress. The interesting thing here is, look, I mean, like I'm doing the tariffs case right now against the president, and the president's like, oh, we need these tariffs, they're super important. And like, if it's that important, go to Congress and get authorization. You control Congress. I mean, but instead, he just unilaterally does it, just as he unilaterally does it with deportation, he unilaterally does it with Harvard. Time and time again, this is past a muscular view of executive power. It's a Looney Tunes view of executive power. It's basically King George III back in 1776. And I thought we fought a revolution about that stuff.
Yeah, there was an interview with President Trump. This is during his first term, but he's really obviously thinks this even more now, where he said, I've got this article of the Constitution, Article 2, that says I can do whatever I want to do. And if you actually read Article 2, even if you tried to read it backwards and you found out like Ringo was dead or something, it still wouldn't say that the president gets to do what the president wants to do. It actually says the president is supposed to take care that the laws are faithfully executed. And he's not, I don't think he's doing any of those words.
Well, he's good at faithful.
Let me ask quickly, beyond confrontation with courts directly, I think you both know the president's also gone after law firms, which are an integral part of the justice system. They're the ones who bring cases before the courts, and he's issued some penalizing orders that have been rejected by district courts. Other firms, have made tried to make accommodations with the White House. How is that affecting the overall atmosphere of the legal system now and the confrontations between the president and people who oppose his policy?
So for those of you who don't know completely about this, what happened is the president has issued executive orders against five law firms that are still in place, although 4 of them have been enjoined permanently by courts. And what these do is they basically defame various people who work at the law firms, announce that the law firms are un-American, and then say that the federal government should make an effort to essentially drive the clients away from these law firms, prevent these law firms from meeting with government officials, prevent them from going into government buildings, take away security clearances and the like. And there are, as I say, there are a whole bunch of these executive orders that were issued. 4 law firms against which they were issued filed lawsuit in federal court. All of those lawsuits have been won by the law firms. And a number of people have speculated that the administration is not even going to appeal those decisions, in part because it got what it wanted, which is it managed to take a whole bunch of other law firms and get them, in the words of Carolyn Leavitt, the president's press secretary, to bend the knee to the administration. And that is something lawyers are never supposed to do. Lawyers do not bend the knee. Colin Kaepernick takes a knee. Lawyers don't take a knee. And the thing about this that's really most pernicious, I think, is not just that you got these firms to do this, but a number of these firms now will not do pro bono work that they think will ire the administration. That is, they committed to doing a whole bunch of close to $1 billion worth of what is called pro bono, but which I actually think should be called at this point uncompensated legal services, because it's not a decision about whether this is in the public interest as much as it used to be. And so the law firms are in this position where there are people out there who would normally be represented by these law firms pro bono, who are finding it very difficult to get pro bono representation from some of these firms, because the firms want to do the kind of pro bono work or the kind of uncompensated legal work that the Trump administration likes, which is things like representing veterans, although presumably not those veterans who are kicked out for being transgender, representing police officers. The administration has suggested that police officers should be represented by these firms in police brutality cases. And news to the administration, these officers are already all indemnified. They are all represented at no cost to themselves already. But I think it's distorting the kinds of cases that you're likely to see, particularly the low-level cases that involve representing just one person in an immigration hearing, or just one person who's challenging what happened to them under the Civil Service Reform Act or the like.
I want to see if we have any questions here as we get in. Okay, how about you?
Neil, I think you referenced Citizens United in an effort to reverse that. Can you talk about that, the process, what the hopes are of that being reversed?
Yeah, so Citizens United is the 2010 Supreme Court decision, 5-4, that effectively said corporations have free speech rights. And then in 2011, the DC Circuit, our nation's second highest court, said this doesn't just apply to corporations, it applies to super PACs, and it applies to the contributions that people make to super PACs. And so you now have a First Amendment right to give effectively unlimited amounts of money to super PACs, and that has completely changed the system of elections in the last 15 years. Super PACs didn't exist until this 2011 decision, and now billions and billions of dollars are flowing in, and that money is dark. We don't know who's giving it. And, you know,
I think Elon Musk was very upfront, though, about.
so certainly can do it. Individuals can do it, but if you're, you know, and you certainly can voluntarily disclose, but it's not required and it's not being disclosed. So Larry Lessig, this Harvard law professor, had this idea to say, well, Citizens United talks about corporations, and it certainly doesn't talk about super PACs, and it doesn't talk about contributions to super PACs. So he got on the main ballot an initiative to ban super PAC funding of more than $5,000 and to require disclosure. It passed in November with 74.9% of the vote in Maine, and overwhelmingly bipartisan. More people voted for that than had voted for any candidate or any referendum in Maine history. It was then challenged by the right-wing groups that want to give this money, and I just argued it in the Maine trial court, and it'll go up you know, hopefully to the U.S. Supreme Court over time.
Okay.
But we think that's an example, even though, you know, I think the court is overwhelmingly conservative and far more conservative than where the country is. There are still pockets of places where we can win, where we can change the system and do good things. And I don't want us to, you know, I don't want you to leave this room and think the courts are just dead to us, because they're not. And at this point, when your only other alternative is Congress, you got to look to the courts.
Yeah.
Hi, you may have just answered my question. Number one, thank you all, three of you, for fighting back. But I was feeling pretty hopeless. And so my question was, what can we do? So maybe I should take it from what can you do to what can we do?
Well, you can vote for candidates who will take seriously their oath of office. And this is not a partisan issue. This is a nonpartisan issue. There are good people and bad people on both sides of the political aisle on this. But vote for candidates that take their oath of office seriously. Speak out in favor of defending the courts when they hold people accountable for what they're doing. And I think that's really important. You know, a lot of this also involves talking to people who don't necessarily agree with you to try and explain to them why it's really important that we have the rule of law, that we don't want to become, you know, the United States of Hungary or, you know, the United States of Turkey or one of the other countries that's had huge democratic backsliding. So I think that that's what I would say is the most important thing to do.
And just I would add to that, you know, in addition to what law and lawyers can do, you know, what you do with your dollars. Do you support NPR after the administration goes after it? Do you support these universities, these law firms, et cetera? There's lots of places in which you standing up and saying, hey, you know, this is wrong, actually matters. And it certainly matters internally to those organizations.
Oh, sure. In front here.
I'm not sure where I read this, and I'm not sure it's even plausible, but is there a scenario where states' attorney generals and state law enforcement go after unidentified ICE agents who are making arrests of people within their states because we don't know who they are? Are they real people? Are they real agents or not? Is that even remotely possible?
So the thing is, state people can arrest folks, but because of something called federal officer removal, even if you're accused of a state crime, if you are a federal official, your case will be tried in federal court. And the question would then turn into whether they were authorized by law to do what they did. Because if they were authorized by law to do what they did, then they can't be convicted under state law for doing it. Whereas if they did something that was unauthorized, then they can be tried.
And the flip side is also quite interesting. I'm representing a bunch of cities that the Trump administration has sued for not enforcing the immigration laws, so-called sanctuary cities. So these are circumstances in which state or local officials aren't turning in undocumented folks. So you go to the emergency room and it turns out you're undocumented. Well, we want to incentivize people to come to the emergency room, so we don't want them to not come because they're worried about the call. So so the Trump administration is saying all of those state laws, state practices are unconstitutional because of something in our Constitution called the Supremacy Clause, which puts federal law over state law. And so they're saying we can supersede any state policies. So, you know, that clash is coming and will be, I think, you know, one of the big things over the next year that you'll be reading about.
Let's see, on this side, in the back.
Thanks. My name is Bill Becker. Neil, I've run into you, so I have first an observation and then a simple question. The observation is, you've all done a good job showing that it's not just the courts that Trump is versing. It's any individual, public or private, any institution that contradicts him, can possibly limit his power, or that contradicts his biases. It doesn't have to be a power issue. His attitude, for example, on climate change, where he's eviscerated federal climate science so that we no longer can predict exactly what's coming, at least at the federal level, and how to prepare for it. And he's done this throughout. He's done it with the press, he's done it with the judiciary, he's done it with whistleblowers. So this is a personality problem on Trump's part, I think. He's been diagnosed as egocentric, and I think he is. So there's a whole bunch of institutions that we need to defend beyond the courts. My simple question is, should the Supreme Court be taking more original jurisdiction now that it's complicated the process of getting a ruling through the system?
Well, its original jurisdiction is limited by statute and by the Constitution, so there are most cases can't be heard by the Supreme Court using its original jurisdiction. The only ones that are clear are ones in which it's a state versus another state, or it involves ambassadors or other public ministers. Otherwise, unless Congress created jurisdiction in the court, it doesn't have the jurisdiction to just be a roving kind of, we'll decide everything ourselves now.
I'm in the front row.
What do you attribute the change in the Supreme Court's position? What do you attribute the change in the Supreme Court's position to? I had always thought of Supreme Court justices as having the best job in the world because they couldn't be touched, they could stay there for life, and what is it that they're intimidated by that's causing them to make this sort of pivot? I mean, what are they afraid of?
Well, I don't know that they're afraid. I think
What's
again.
the cause?
So I think the cause is, and it's not a change. I think this is true at the Supreme Court going all the way back to the founding, because they don't have any way of enforcing their judgments except norms and the goodwill of the administration. I think every Supreme Court is always concerned with clashes between the presidency and the courts. So the most high-profile example is FDR. So the Supreme Court in 1935 strikes down various New Deal initiatives. FDR runs in 1936, sweeps the country, I think he wins 48 states, wins them by an overwhelming margin, and then gives a fireside address in which he says, Supreme Court is stymieing my will. I'm proposing that we go up to 15 justices on the court. The court hears that message and changes its votes. It's called the switch in time that saves 9, and starts upholding the New Deal. So Trump is in a way running a version of that playbook. Now he's saying, attacks the justices when they do something he doesn't like. Yesterday in his press conference, reads the names of all 6, thanking them as great Americans. So he's playing that game. It's not clear to me, and this was Jess's question, it's not clear to me it's working. Like, I think, the 11 of the 12 decisions that side with him, they might have done it anyway. There's 2 ways of reading this. One, they're being intimidated by the president, which is, I think, the basis of your question. The other is they're not intimidated, but they know they can't say no to the president every time without it leading to a massive constitutional crisis. So they're conserving their resources for the cases that really matter.
Well, isn't it also?
But it's also a little bit like, in some sense, it's a little bit like those guys in college who would go up to every girl at the happy hour and ask her to come back to their room, and they knew they were only going to bat like 100, but if they asked 27 people, chances are somebody would say yes. And that's kind of where Donald Trump is right now, which is he's just throwing every outrageous thing up there and assuming, like the ancient mariner, they're only going to stop 1 in 3 or something. I mean, there's a little bit of that going on. Usually I agree with Neil on almost everything, but the switch in time is actually a little more complicated because one of the things that I think happened there was the early New Deal legislation was drafted very badly, and the Supreme Court kept striking it down and striking it down. And then they got better lawyers in there. And the later cases, like Jones and Laughlin, involved better drafted statutes that did comply with the Constitution. Also, the court recognized something during the New Deal that I think was really important, which is we were in a crisis as a country. And you see this most clearly, I think, in the Minnesota against Blaisdell case, which is a case about moratoriums on kicking people out of their homes for their mortgages. But the court recognized we were in a crisis. And what's bizarre about the current Supreme Court is the majority of them are acting as if Donald Trump is a totally normal president.
Yeah.
You know, and therefore, the things that you would do with a totally normal president, which is you would give a huge amount of deference to the president's views about policy and the like, and to the good faith of the administration in doing what it does. But when you have a president who's acting in bad faith, the court's failure to kind of recognize that is I think some of what's going on is they're just acting as if this is all, you know, just routine.
That's exactly right. I mean, I think the court is thinking about it, hey, this case isn't about Donald Trump, it's about the next president, Wes Moore, or whoever it may be, and my governor. But the kind of interesting coda to that is, in the Biden administration, I don't think that's how they approached it. I mean, the court struck down Biden initiative after Biden initiative, whether it was the Clean Power Plan, whether it was COVID, you know, restrictions, the eviction moratorium, whether it was greenhouse gases, you know, regulation in other spaces. Time and again, Biden student loan plans, they kept on inventing doctrines to say, oh, you can't do that. That's a major question. You don't have the authority. You got to go to Congress. So they were playing, I think, a much more Biden-specific game there. And it's a really interesting question. Maybe it's intimidation, maybe it's something else, for why they're not applying quite that same perspective to this president and asking, as Pam, I think, rightfully does, hey, this isn't a normal president. Maybe we can't have the same rule book.
Now, we're out of time, so I want to just, before we thank our panelists, just sort of say, I think that we all feel a lot better about our country now, and how many of you now think that we are heading towards a constitutional crisis? Okay.
Oh, well.
All right. Well, we're gonna work on the material and try to improve it. But thank you all. Please thank Neil and Pam.